Hi everyone, my name is Shazia Khan and today's session is on criminal law. The unit is criminal law, and the learning outcome we'll be looking at today is learning outcome 3, which is to understand property offences. We looked at learning outcome in the last session, which was learning outcome 2, which was to understand the elements of different offences against a person. We looked at the different components of murder. We also looked at voluntary and involuntary manslaughter. We looked at the nature of non-fatal offences against the person. As we said, we looked at the components of murder with actus reus and mens rea. We also looked at the issue of mens rea with reference to case law. We looked at causation in criminal liability and the importance of that. And we looked at cases such as where there's no novice actus intervenius, such as R and Paget, R and Roberts. We also looked at the thin skull rule, the case of R and Haywood. We also looked at the intention to murder, direct intent, oblique intent, and subjective test. We looked at voluntary and involuntary manslaughter with reference to cases such as R and Duffy, the Bedder case, and Davies. We also looked at provocation, and with reference to the Coroners and Justice Act 2009, diminished responsibility, gross negligence, with reference to case law such as R and Seymour and DeMarco. And we looked at actual bodily harm and grievous bodily harm with reference to cases again, and also looked at the issues around actus reus of GBH and ABH and mens rea of GBH and ABH. And today we'll be looking at the issue regarding learning outcome 3, which is to understand the importance of property offences. So what we'll be covering today. So we're going to look at explaining the components of property offences, distinguish between lack of honesty under Section 2(1) of the Theft Act 1968 and dishonesty under common law. We're going to compare and contrast robbery with burglary. With all this, we will be referring to case law as well. So 3.1, explain the components of property offences. So the law of offence of theft is set out in Section 1 of the Theft Act 1968, and Section 1 identifies that it provides that a person is guilty of theft if they dishonestly appropriate property belonging to another with the intention to permanently deprive the other of this property. The defendant can only be charged under Section 1, while Section 2 and 6 defines the elements of Section 1 and Section 7. So the actus reus of theft, appropriation. For an appropriation to take place, there is no requirement that that all the rights of an owner are assumed. One right is sufficient. And the case example for that is the case of Aaron Morris, 1983, in regards to this identified the definition of appropriation in the offence of theft. And in this case, the facts are that the defendants were convicted of theft under Section 1 of the Theft Act 1968 after switching the labels on products in a supermarket to obtain a lower price. One of the defendants was caught before he paid, while the other was only caught afterwards. The issue that was identified in this case was that Section 1 of the Theft Act defines theft as dishonestly appropriating the property of another with intention to permanently deprive. Section 3 of the Act defines appropriation as an assumption by a person of the rights of an owner. The defendants argued that switching labels on the products and paying a lower price did not amount to appropriation. The decision and the outcome in this case was that the convictions were upheld by the House of Lords. They held that the owners of the goods had a right to ensure that they were sold for the price the owner chose, which the defendants usurped when they switched the labels to be able to pay less. This amounted to an assumption of the owner's rights, and therefore it amounted to appropriation. The Lords also noted in this case that this meant that the relevant appropriation and therefore the actus reus for the offence of theft was complete as soon as the goods had been removed from the shelves and the label switched, regardless of the order in which this was done. It did not matter whether the defendants had yet paid for the goods, the offence of theft was already complete. They also stated that the offence of obtaining property by deception under section 15.1 of the Act should therefore be considered an additional rather than alternative offence committed once the defendants had paid at the checkpoint. In the interest of simplicity, however, prosecutors might only charge the section 15 offence in such a situation rather than both the section 1 and section 15 offences. The actus reus of theft, and we're going on to property. Continued. Property includes money and all other real or personal, including things in action, other intangible property, and belonging to another. For the theft to, there to be theft, the defendant must have appropriate the property. 5 types of items which are included the definition of property: money, which includes coins and banknotes of any currency. Personal property covers all movable items, which include books, clothes, and or cars. Real property also is a legal term for land and buildings. These things can be stolen, but only under 3 circumstances. Firstly, when a trustee or a personal representative takes land in breach of his duties. Secondly, a tenant takes a fixture of structure from the land let to him. And thirdly, someone not in possession of land serves anything forming part of the land. Then the next one in regards to property is things in action. That includes checks and bank accounts. And then in the definition, other intangible properties refers to things which have no physical presence but can be stolen. For example, a patent. However, information about something cannot be stolen. And the case is in regards to that, which is the first case we're going to be looking at, is the case of R and William, 1989. In this case, the defendant had taken money from his employer's safe and claimed that he intended to pay it back after the weekend. The Court of Appeal held that he had not intended to return the exact coins and notes, and that therefore he was properly convicted of theft. The next case was the case of R and Smith, and this was robbery of drug dealer constituted theft under the Theft Act. So the facts in this case is Mr. Smith and his 2 co-appellants P and H arranged to meet a drug dealer. Upon meeting the drug dealer, they violently attacked him and stole around £50 worth of heroin. The 3 were subsequently convicted of robbery. The issue in this case was that S, P and H challenged their conviction on the basis that the alleged offence was not known to the law because the heroin in question was unlawfully in the possession of the victim. Accordingly, it did not constitute property in terms of Section 4 of the Theft Act 1968, and therefore there could be no appropriation. The decision in this case by the Court of Appeal, the Court of Appeal noted that while Section 4 of the 1968 Act identified a number of items which could not be stolen, these exclusions did not extend to property which was unlawfully possessed. Nothing in the 1968 Act suggested that property which was possessed or controlled in an unlawful, illegal or prohibited manner lost the status of property in terms of the Act. Therefore, the appropriation of the prohibited drugs constituted theft, and the circumstances in which the appropriation took place amounted to robbery. The convictions were therefore upheld. The court also noted the public policy considerations which might suggest that a wrongdoer, for example, the drug dealer, should not be able to enforce a property right, are not relevant to the application of criminal law, which is principally concerned with keeping the peace rather than vindication of individual property rights. The next case is a case in regards to an exam paper. In Oxford and Moss, I'll give you a little bit on the facts of that case. A student borrowed an advanced copy of an examination paper, copied the questions and then returned the paper. The divisional court held that he was not guilty of theft on the basis of that information could not be stolen. Clearly, the paper on which the exam questions were typed was property belonging to Liverpool University, but there was no evidence that the defendant intended to permanently deprive the university of this. The next element of the actus reus of theft is belonging to another. So property will be regarded as belonging to any other person having possession or control of it. The possession or control of the item does not have to be lawful. Where B has stolen jewelry from A and subsequently C steals it from B, B is in possession or control of that jewelry. The wide definition of belonging to another has led to situations in which an owner can be convicted of stealing his own items. An important case in regards to that is the case of Aaron Turner. In this case, it was about theft of a car which was in the possession and control of the garage. In this case, the facts are that the defendant, T, took his car to a garage for repairs. The repairs were completed by the garage and the car was left outside the garage on the road. T called the garage and told the proprietor that he would return the following day, pay him and take the car. Instead, he took the car from that roadside several hours later without paying for the repairs. The issue was that T was charged with theft of the car contrary to Section 1 of the Theft Act 1968. He submitted that in terms of Section 1, Section 5, subsection 1 of the 1968 Act, the car did not belong to the proprietor of the garage, and the appropriation of the car by him was not dishonest without the meaning of Section 2, subsection 1A of the 1968 Theft Act. The Court of Appeal dismissed T's appeal. The Court of Appeal held that the property belonged to a person if at the time of the appropriation that person was in fact in possession or control of it. The words possession or control in Section 5, subsection 1 of the 1968 Act did not require to be qualified in any way. For example, the person from whom the property is taken must in fact be in possession or control of any question of legal possession or control, for instance, through a hire purchase agreement, was irrelevant. Secondly, the Court of Appeal confirmed that the trial jury had been properly directed that it was essential for the prosecution to show that T had acted dishonestly, and his ill-founded belief that he had a lawful claim of right to take the car in the circumstances were immaterial. So the law of theft, the mens rea, we're going to look at now. So dishonesty, there's no definition, statutory definition of dishonesty. Although Section 2, subsection 1, Theft Act, gives 3 instances of when a person is not to be regarded as dishonest. So firstly, if he appropriates the property in the belief that he has in law the right to deprive the other of it on behalf of himself or of a third person, or 2, if he appropriates the property in the belief that he would have the other's consent if the other knew of the appropriation and the circumstances of it, or number 3, if he appropriates the property in the belief that the person to whom the property belongs cannot be discovered by taking reasonable steps. These 3 exceptions are judged entirely subjectively. There's no requirement that the defendant's belief is reasonably held. The case in regards, the leading case is the case of R and Holden, 1991. In this case, the appellant worked for Quick Fit. He took some used tyres and was convicted of theft. He appealed, contending that he was not dishonest since other workers did the same, and he believed that he was allowed to do the same. However, his contract of employment contained a clause forbidding the taking of used items. It was held in that his conviction was quashed by the Court of Appeal. The question of dishonesty under exception Section 1, subsection 1 of the Theft Act 1968 is judged entirely subjectively. It is the defendant's belief alone that counts, not what he has actually permitted or forbidden from doing. Mens rea, intention to permanently deprive. Under Section 6, subsection 1, Theft Act 1968, a person is treated as having the necessary intention if they treat the property as their own, regardless of the owner's rights. This covers situations where the defendant intends to return the property to its owner, for example, the stealing of a store gift voucher and using it in the store to pay for the goods, as in the case of R and Lavender 1994. In this case, the defendant removed some doors from a council property that was due for demolition. He installed the doors in his girlfriend's flat, which was also owned by the council, and it was held in this case that he did not have the intention. He did have the intention to permanently deprive under Section 6, subsection 1, as he treated the doors as his own to dispose of regardless of the owner's rights. 3.2, distinguish between lack of honesty under Section 2, subsection 1 of the Theft Act 1968 and dishonesty under common law. So Section 2, subsection 2, Theft Act 1968 states that a person may be dishonest, notwithstanding a willingness to pay. This is perhaps a little unhelpful in determining dishonesty. Honesty, since it does not state whether a person will be honest or not, but simply may. The question of dishonesty must be left for the jury to decide. And the leading case for this is the case of R and Feely. And in this case, the defendant was a branch manager of a firm of bookmakers. The firm sent around a notice to all branch managers that the practice borrowing from the tills was no longer allowed. Regardless of the notice, defendant took money from the branch safe. Defendant was then transferred to another branch and the cash shortage was discovered. Defendant gave the successor branch manager an IOU for the amount. Defendant took the firm's security staff that he borrowed the money because he was short of cash and he intended to pay it back. Furthermore, the defendant's employers owed him some money. The trial judge directed the jury that there was no defense for defendant to say that he intended to repay the money and that his employers owed him more money than enough to cover that he had taken. The defendant was convicted of theft. The appeal was allowed. Judge Lawton delivered the opinion of the court, and the judge did not leave the jury to decide whether the prosecution had proved the defendant had taken the money dishonestly. Under the applicable statute, theft occurs when a person dishonestly appropriates property belonging to another with the intention of permanently depriving them. Dishonesty under common law. In situations not covered by Section 2, where the defendant claims that he is not dishonest, the Gosh test applies. In the Gosh case, 1982, the defendant Gosh was a locum consultant at an hospital who falsely claimed to have carried out a surgical operation in order to claim money, when in fact the operation had not been carried out. Operation had been carried out but by someone else under the National Health Service. He was charged with attempting to procure the execution of a cheque by deception contrary to Section 20, subsection 2 of the Theft Act 1968, and obtaining money by deception under Section 15, subsection 1. His defence was that there had been no deception as he was entitled to the money, and he appealed to the Court of Appeal against his conviction. And the decision in the case was that dishonesty was a state of mind, not a cause of conduct, and the test under 1968 Act was both subjective and objective. First, the jury must decide whether the defendant's conduct was dishonest according to the standards of reasonable and honest people as the objective test, and then if it was not, then it would be the end of the matter. If it was dishonest by those standards, the jury then had to go on to decide whether the defendant himself realized that what he was doing was dishonest by those standards, which is the subjective test. If it was, then the defendant was dishonest under the 1968 Act. 3.3, compare and contrast robbery with burglary. Under Section 8 of the Theft Act, a person is guilty of robbery if he steals and immediately before or at the time of doing so, and in order to do so, he uses force on any person or puts or seeks to put any person in fear of being then and there subjected to force. In criminal law, robbery is a form of aggravated theft in that it involves the offence of theft plus force or threat of force on a person. The maximum sentence for robbery is life imprisonment. Robbery is theft aggravated by the threat or use of force, as I've mentioned in the definition. The elements of theft must be established if a conviction for robbery is to be obtained. Thus, for example, a person who forces another to hand over money, believing that he has a legal right to do it, he is not guilty of theft. The actus reus of robbery. So steals. This element of actus reus of robbery requires that all elements of theft must be established. And the case in regards to this is the case of Aaron Robinson, 1977. I'm going to go through a variety of cases. Okay, so the other cases you can look at in your own time. Aaron Robinson, 1977. In this case, it was alleged that D, who was owed £7 by V's wife, approached V brandishing a knife. A fight followed during which V dropped a £5 note. D picked it up and demanded the remaining £2 owed to him. Allowing D's appeal against conviction for robbery, the Court of Appeal held that the prosecution had to prove that D was guilty of theft and that he would not be under Section 2, subsection 1A of the Theft Act 1968 if he honestly believed that he had the right in law to deprive V of the money, even though he knew he was not entitled to use the knife to get it. Another case in regards to the issue of stealing is the case of Coran and Anderton, 1980. In this case, two defendants knocked a woman to the ground and grabbed her handbag. She screamed and held onto the bag. They let go of the bag and ran off empty-handed. They were convicted of robbery and appealed, contending that at no time did they have sole control of the bag. It was held that the convictions were upheld. An appropriation had taken place with the relevant dishonest intent to permanently deprive. It was irrelevant that they left empty-handed or they had never gained full control of the bag, since touching property is sufficient to amount to appropriation. So the next one is immediately before or at the time of stealing. The offence of theft is complete as soon as the appropriation has taken place. On a strict interpretation of the statute, use of force to escape with stolen property would fall outside the ambit of the offence. And the leading case for this is the leading case of Aaron Hale, 1978. In Aaron Hale, D and E entered V's house, and while D was upstairs stealing a jewellery box, E was downstairs tying up V. The Court of Appeal refused to quash their convictions for robbery, though the appropriation of the jewellery box might have been completed before the force was used. The court said that the appropriation should be regarded as a continuing act, and it was open to the jury on the facts to conclude that it continued while V was tied up. The matter needs to be looked at in a common sense way. While the force must be used at the time of the theft, and in order to steal, the theft needs to be looked at in its entirety. The next case to look at is the case of Aaron Lockley, 1995. In this case, the defendant stole cans of beer from an off-licence. The shopkeeper tried to prevent him leaving the shop with the stolen items, and the defendant assaulted the shopkeeper to escape. The defendant was convicted of robbery and he appealed against its conviction, arguing the decision in Aaron Gomez and overruled the decision in Aaron Hale on the issue as to whether appropriation was a continuing act. The decision in this case was that R.V. Hale had not been overruled on the point in issue by the decision in Aaron Gomez. For the purposes of robbery, appropriation is a continuing act, and it is for the jury to decide whether the theft is complete prior to the use of the force. The defendant's conviction for robbery was upheld. Force or threat of force. The required level of force used for robbery is a question for the jury to decide. The jury are given no guidance as to meaning of force. The Court of Appeal has been unwilling to interfere with jury's findings, even where the level of force is minimal, as in the case of Aaron Dawson and James 1976, where the defendant had nudged the victim, causing him to lose his balance so that his wallet could be more easily taken. His appeal against a conviction for robbery was refused. There's no requirement that the force is directly applied to a person, and that's in the case of Aaron Clouden, 1987, where the defendant had pulled on the victim's handbag to wrench it from her hands. The Court of Appeal held that whilst a snatching of property without resistance from the owner, such as by a pickpocket, should not amount to robbery, the question of whether force has been used on any person should be left to the jury. The defendant was held to have been rightly convicted of robbery. In order to steal, Section 8 requires the use of threat of force to be in order to steal. Thus, the use of gratuitous violence at the time of stealing, but not used in order to steal, is strictly speaking outside the boundaries of the offence of robbery. Similarly, if a person hits another with the intent to do GBH and knocks him unconscious, then decides to steal his wallet, would not be guilt of robbery, although this point has not been litigated in the appeal courts, and it may well be that a robust approach is taken. Mens rea of robbery. Mens rea: in order to steal, the defendant must have the mens rea of theft, dishonesty, and intention to permanently deprive. Now we'll go on to burglary. The offence of burglary is set out in Section 9 of the Theft Act 1968. Burglary is an offence which can be tried either way, that is either in the magistrates' courts, summarily, or in the Crown Court on indictment, depending on how serious the case is. If it is decided that it is less serious, it will be heard in the magistrates' courts where there's no jury. If it's more serious, it will go to the Crown Court to be heard by a judge and a jury. There are two offences of burglary created under Section 9, burglary under Section 9(1)A and burglary under Section 9(1)B. Burglary under Section 9(1)A is a person commits burglary under Section 9(1)A if he enters a building or any part of the building as a trespasser with the intent to either, number one, steal anything in the building, number two, inflict GBH on any person in the building, and number three, or doing unlawful damage. And the leading case for that is the case of Aaron Collins, 1973. In this case, the defendant, having discovered that a woman was lying asleep and naked on her bed, stripped off his clothes and climbed up the ladder onto the windowsill of the bedroom. At this moment, the woman awoke and, mistakenly believing that the naked form at the window was her boyfriend, beckoned the defendant in. The defendant then got into bed, and it was only after the defendant had intercourse with her that the woman realized her error. The defendant's conviction for burglary, entering as a trespasser with the intent to commit rape contrary to Section 1A, was quashed on the basis that the jury was never invited to consider the vital question whether the defendant did enter the premises as a trespasser, that is to say, knowing perfectly well that he had no invitation to enter, or reckless, or whether or not his entry was with permission. It's very important to note that another difficulty of the of the case lay in determining whether the defendant had entered the building before or after an invitation to enter had been made. If he was already inside the room, having climbed through the window frame and kneeling upon the sill before an invitation has been made to him, he would already be guilty of burglary, for he had entered the intent to rape, and the victim's subsequent consent could not alter that. If he was kneeling on the sill outside the window, he would not have been guilty of burglary, as the invitation to enter had been made while he was still outside the premises. Burglary under Section 191B. A person commits an offence of burglary under Section 9 subsection 1B if, having entered as a trespasser, he steals, attempts to steal anything in the building, or inflict or attempts to inflict GBH on any person therein, steal anything in the building, inflict GBH on any person, or doing unlawful damage. The main difference of the two offences of burglary is that under the intent must be formed at the time of entry, whereas under the intent to commit the ulterior offence can come later. Also, A covers unlawful damage, whereas B does not. Actus reus of burglary, the first one is entry. Initially, it was held that to amount to an entry, the defendant had to make a substantial and effective entry, and the case in regards to this was the case of R and Collins, which we talked about earlier on. However, later cases suggest this is no longer required, as in the case of R and Brown, 1985, and this identified the meaning of entry under the Theft Act. In this case, the defendant Brown broke a shop window and stuck the top half of his body through the hole while rummaging around inside the shop in order to steal the contents. His lower half remained outside the shop. He was arrested and convicted of burglary under Section 9 of the Theft Act 1968. He subsequently appealed against his conviction to the Court of Appeal. The decision in this case was that entry had to be effective, but the word substantial was not considered to be one of additional help. Therefore, all that was required was either an effective or a substantial entry. Here, the entry was effective, therefore the offence was complete. Entry could still be effective even if the defendant did not enter the premises with his whole body. The defendant had entered with intent to steal, therefore the appeal was dismissed. Next case to look at is the case of R and Ryan, 1996. And in this case, the defendant Ryan was discovered in the early hours of the morning, stuck inside the window of an elderly person's house, and had to be removed by the fire brigade. He had managed only to get his head and one arm inside the window. He was convicted with burglary and subsequently appealed against his conviction to the Court of Appeal. The decision in this case was the fact that nothing was stolen was only because he had gotten stuck. In any case, it was irrelevant whether anything was actually stolen or not. The defendant partial presence within the building amounted to entry under Section 9 subsection 1 of the Act. The court applied R and Brown 1985 in regards to this, and stated that a person could enter a building if only part of his body was actually inside the premises. The court agreed that with the trial judge's findings that it was up to the jury to decide whether there was entry or not based on the facts of the case. Actus reus of burglary continued. Building or part of a building, Section 9 subsection 4 states that inhabited vehicles and vessels are included even if not inhabited at the time of the offence. This provision was considered in the following cases: So the first one, the leading case, is B&S versus Leithley, 1979. In this case, the defendants B&S entered a freezer container that had been placed in a farmyard and stole goods from it. The container was resting on sleepers, weighed 3 tons and was 25 foot long by 7 feet. It had not been removed for over 2 years, had a door and locks, and was connected to the electricity supply. The defendant was charged with burglary and subsequently appealed the decision to the Crown Court. The decision from the court was that the container was a building for the purposes of the 1968 Act. The court referred to Stevens and Goley 1859, which predated the Act, in which it was held that a building was a structure of considerable size and intended to be permanent or at least to endure for considerable time. The container fulfilled this criteria as it was likely to remain there for a foreseeable future. Therefore, it was a building for the purposes of 1968 Theft Act. Consequently, the defendant's appeal was rejected. The next case was the case of Norfolk Constabulary and Sea Kings and Gold, 1986. In this case, the defendants Sea Kings and Gold were convicted of attempted burglary of 2 articulated lorry trailers that were being used as temporary storage space during the building work on a supermarket. The trailers had been unhinged and stood on their own wheels and struts. An electric cable was attached to each trailer to supply lighting and heating. Steps had also been built against each trailer, and access was gained by the ordinary trailer shutters. The trailers had been used in the way for about 1 year. The defendants appealed against the conviction in the Crown Court. It was held that the appeal was allowed. The court held that the trailers were not buildings for the purposes of the 1968 Act. The court pointed out that Section 9, subsection 4, Theft Act 1968, specifically says that a vehicle is not only a building when it is inhabited, whereas a building may be burgled at any time, whether inhabited or empty. The adaptations made to the vehicles did not mean that their character was changed from what was essentially a vehicle. The court distinguished B&S against Leithley, as in the case the trailer had no wheels and was immobile. Entering part of the building was considered in the leading case of Aaron Walkington. In this case, the defendant Walkington was in a department store when he went behind the unoccupied counter area on the shop floor and opened the cash till drawer. On seeing it was empty, he left and was arrested by a store detective. He admitted that if he had any money in it, the till, he would have stolen it. He was convicted of burglary, appealed to the Court of Appeal, and it was held that the Court of Appeal dismissed the appeal. The court held that the area behind the counter was part of a building under Section 9, subsection 1A of the Theft Act 1968. Therefore, it was for the jury to decide whether the defendant had entered it as a trespasser. The court held that an intention to steal can exist even though unknown to the accused there is nothing to steal. The fact that the till was empty did not destroy the defendant's intention to steal. Actus reus as a trespasser. This covers those who may have permission to be in the property but exceed the permission by doing something which they were not invited to do so, as in the case of Aaron, Jones and Smith, 1976, which in this case, the defendants Jones and Smith entered Smith's father's house and stole 2 television sets. At his trial, Smith said that his father had given him unreserved permission to enter the house. They were convicted of burglary and subsequently appeal. The appeal was dismissed. A person who has general permission to enter a premises may still be a trespasser if he enters knowing he is acting in excess of permission given or being reckless as to whether he is so acting. The court quoted from the Calgarth 1926 Lord Justice Scruton, when you invite a person into your house to use the staircase, you do not invite him to slide down the banisters. The court rejected the defendant's argument that it did not matter what, as in the defendant's minds, when they entered, so as long as they had permission to enter. What mattered was whether the defendant was in the possession of facts which enabled him to realise he had exceeded his permission or was reckless as to whether he exceeded it. The defendants had entered the premises knowing that they had exceeded the permission given. Therefore, they were trespassers. Mens rea of burglary. The defendant must know they are trespasser or to be reckless as to whether they are trespassing. As we mentioned in the case of Aaron Collins earlier, aggravated burglary. Section 10 of the Theft Act 1978. Under Section 10, a person will be guilty of aggravated burglary if he commits any burglary and at the time of the burglary has with him any firearm or imitation firearm, any weapon of offence or any explosive. The relevant time for possessing the weapon depends on whether it is a Section 9, subsection 1A offence or a Section 9, subsection 1B offence. If A, then possession must be at the time of entry. If B, possession must be at the time the ulterior offence is committed, as in the case of Aaron O'Leary, where the defendant entered a house without a weapon. Once inside, he took a knife from the kitchen and took it upstairs to effect the burglary. It was held that the offence was charged under Section 9, subsection 1, B, and there was thus no requirement that he had the knife at the time of the entry. His conviction was upheld. There is no need to establish the defendant intended to use the weapon in the burglary, as in the leading case of Aaron Stones, 1989. In this case, the defendant Stones was caught running away from a house that he had burgled. When he was arrested and searched, he was found to be carrying a kitchen knife, and when he claimed was for self-defence because some lads from Blythe are after him, he was charged with aggravated burglary under the Theft Act 1968. The appeal in this case was dismissed as it was sufficient to show that the defendant knowingly had the knife with him with the intent to cause injury to some person. There was no need to show that he intended to use it in the course of the burglary, saying that he intended to use it for self-defense, showing that he intended to use it to cause injury. The trial judge had erred, but it was a mistake that was advantageous to the defendant, so he could not complain about it. Principal offences under the Fraud Act 2006. The Fraud Act 2006 repealed the following offences: Theft Act 1968, Section 15, obtaining property by deception; Section 15A, obtaining a money transfer by deception; Section 16, obtaining pecuniary advantage by deception; Section 20, subsection 2, procuring the execution of a valuable security by deception, and reference to cheat in Section 25, going equipped. They also repealed the following act: Theft Act 1978, Section 1, obtaining services by deception, and Section 2, evasion of liability by deception. So offences: Section 1 creates a general offence of fraud and introduces 3 ways of committing it, which are set out in Sections 2, 3 and 4. Fraud by false representation, Section 2. Fraud by failure to disclose information when there is a legal duty to do so, Section 3, and fraud by abuse of position, Section 4. In each case, the defendant conduct must be dishonest. His or her intention must be to make a gain or cause a loss or the risk of a loss to another. No gain or loss needs actually to have been made. The maximum sentence for this is 10 years imprisonment. And that's all for today's class, and see you in the next class, which is Learning Outcome 4, and thank you for your patience. References for this session are listed just below, so if you need to refer to the books, they are listed below, and also additional resources are available for you to refer to on Moodle, and any additional cases that we've not gone through are on Moodle for you to refer to. And I will see you in the next session, which is Learning Outcome 4, and thank you for attending today's session, and thank you for your patience.